Donald Trump back in court today. What are we on, like day 14 now, I think, of this trial? I brought in good friend of the show, Chris Murray. He's a partner with First and 14th Law. He's served on a number of presidential campaigns, political campaigns as legal counsel. And so I thought he could give us the best insight to really what is a political prosecution. But Chris, thanks for being on the Jeff and Bill Show.
It's good to be with you as always. What a time to be alive, Jeff.
Let's start with the Trump trials in New York. How's it going for the prosecution there? Do you think they're making their case?
Well, I mean, I think they're trying, right? I mean, so just a good reminder for your listeners about what is their case? Like, what is this case about, right? And everybody calls this, it's the hush money trial. It's the hush money trial. What this case is about is an attempt to criminalize 2 settlement payments that were made to a porn star and a former Playboy model right before the 2016 election to essentially buy their silence about alleged encounters with then candidate Trump.
And this wasn't the only one. There was a doorman, too, that they paid off $50,000, and his story was total baloney.
Right. That's exactly right. And what's being charged in New York is essentially what the Federal Election Commission and the Department of Justice refused to charge, which is that New York is alleging, look, hey, these payments benefited Trump's campaign, right? That means that they're illegal campaign contributions, undisclosed campaign contributions, either from the Trump organization to the Trump campaign or from the National Enquirer to the Trump campaign. The Federal Election Commission refused to bring criminal charges in either one of these cases.
And they did in a similar instance with Hillary Clinton on the Steele dossier. So they basically said this was not recorded properly. This was a campaign contribution. And Hillary Clinton, in that case, paid a fine.
So, correct. And by the way, the National Enquirer paid a fine for the Karen McDougal payment.
Oh, did it?
Yeah, the FEC said, hey, look, this is an undisclosed improper campaign contribution. The National Enquirer didn't fight it. They just said, all right, so we pay a fine, no big deal.
They're used to doing that.
Yeah, right. But I mean, that's civil liability. That's not a crime.
Right.
What the New York Attorney General is saying, you cooked your books, you falsified your business records to make the payback to both the National Enquirer, right? Payments to the National Enquirer and payments to Michael Cohen, remember him, look like payments for legitimate services when actually what they're payments for is paying them back for illegal campaign contributions, even though there was no criminal prosecution brought by the federal government.
And that's unique because New York can't necessarily prosecute for a federal election. They could prosecute for a state-based election, right?
Right. But I mean, the charges that are being brought are essentially falsifying business records in order to cover up criminal activity.
Right.
And it is a Class E felony. Like literally, it's like the felony you get when there's no misdemeanor that fits. It's the lowest level felony in New York, and this is typically for stuff like tax evasion. I've never seen it. I work in the political area. I've never seen this sort of a prosecution for a campaign finance related to a campaign finance issue.
Wow. So what happened in the DA's office, though, early on was that they didn't think that this was Alvin Bragg didn't want to prosecute this, right? Early on.
That's right.
And changed his tune.
And that's right. Initially, he was planning to decline this. And he did change his tune. Why? Nobody exactly knows.
Because Colangelo showed up.
Right. Well, but I mean, I don't know exactly what went on in Alvin Bragg's mind. Right. But he did change his mind and decide to bring these charges after initially, I think, properly saying, hey, look, if there's no underlying federal crime, that's the campaign finance violation, then how can there be a New York crime for falsifying business records to cover it up?
So are they successful in prosecuting this from your perspective?
I mean, so far, look, like, what are they trying to do? They're trying to show the jury so far in trial. They've brought out recently they've had David Pecker, who's the head of the National Enquirer. Right. He's been on the stand for a few days, and they've basically laid out like, look, what did you do with the Karen McDougal story? She's the Playboy model who we hear a lot less about than Stormy Daniels, because I guess between the two, she's less of a self-promoter. And this, look, they say, look, you caught and killed this, which means you bought the story and then you didn't publish it. And he basically said, yeah, I did do that. Right. And they're asking, well, why did you do that? Well, I thought it might be an interesting story and I might want to run with it. I wasn't sure at the time, but I wanted to have the exclusive rights to the story. And the prosecution's trying to say, well, wasn't Donald Trump your friend? Weren't you trying to help Donald Trump by buying the story and killing it? And so far, Michael Pecker on the stand has said, look, I wouldn't have minded helping Donald Trump. I like Donald Trump. I'm friendly with him. It's no secret, right? But this woman said she had a great story. Once we got the rights to it, we decided it wasn't worth publishing. It wasn't that good.
So that would demonstrate that there's not a conspiracy to help Donald Trump in his campaign.
Correct.
Right.
Okay. Now, I'm going to jump in. I'm not certain that's not my impression of Pecker's testimony in that area, because Pecker said that publishing the story and publishing those stories would benefit National Enquirer. And then when asked about not publishing the story, he said there was no benefit to National Enquirer for not publishing it, but there was a benefit to the Trump campaign. So the idea that I believe that the prosecution has done a decent job of at least connecting the dots, saying that National Enquirer did not make this decision alone because they thought it was a bad story. They made this decision in part or mostly because it would help Donald Trump's campaign, because this is a giant story. In fact, one of the guys that's one of the assistant editors at the time has come out since then with an interview and saying, this is what I was pissed about, because I left my media career in order to break stories like this. This is a hot story. And then we shelved it. And he talks about going into Pecker's office and having an argument with him. So I disagree with the characterization of National Enquirer making a business decision to not publish the story. It seems to be more, based on the testimony so far, a political decision.
Yeah, I mean, I'll say that. Pecker did say I want to be careful. He's got a heck of a last name. So he did say basically exactly that, Bill, that in retrospect, right, there was no benefit to the National Enquirer by not publishing it, and there was a benefit to the Trump campaign. He did not say that at the time. That he actually affirmatively denied that at the time, that's why he didn't run the story. He says now, looking back on it, that's correct, that there was no benefit to the Enquirer by not running it, and there was a benefit to the Trump campaign. And I think he even said, and that's why, by the way, we didn't contest a slap on the wrist from the FEC, because in retrospect, we get it. So I think what you just said is fair. I also think that, and you're also right about the interview with I forget the gentleman's name. Who worked for the National Enquirer, but that gentleman hasn't testified yet.
Right? It was an outside interview.
And I think the prosecution might want to think about calling that person.
Me too. I was surprised he wasn't on the list.
Right.
Honestly.
Well, so I was about to say, but he's not a disclosed witness, so it may be that the prosecution doesn't believe him.
Yeah. Could be a number of things.
Michael Cohen has been utilizing his evenings to comment on the case and raise money. In doing so via TikTok. Prosecutors seem to not like that. Why is that?
Well, they don't like it because they're trying to get President Trump thrown in jail for violation of this gag order, right? So I know a lot of your listeners follow this. There's a gag order in the case, just like basically anytime Donald Trump goes on trial, here's the script, right? All right, we're going to force him to show up in court. We're going to make him really angry. We know that he's going to get on Truth Social late at night. We wait for him to send one objective, one semi-mean tweet.
Or even a link to an article.
Right. To basically say anything about the case or anybody in it, and then we get a gag order on him. And then the story starts becoming about enforcing the gag order versus the trial, right? So why do the prosecutors not like what Michael Cohen's doing? Well, because Michael Cohen's one of their witnesses. And Michael Cohen is an important witness here, because Michael Cohen was the National Enquirer made the payment to Karen McDougal. Michael Cohen made the payment to Stormy Daniels, right? And the prosecution's case really needs Michael Cohen to be credible. And the prosecution has got a gag order that basically says Donald Trump can't go on social media, can't make comments about reasonably foreseeable witnesses and a whole bunch of other people, including family members of the court, unless he's attacked. And with Michael Cohen going on social media, raising money, saying mean things about President Trump, it basically opens the door for Donald Trump to say whatever he wants on social media about Michael Cohen.
Now, the argument is this is what happens in criminal trials. If you're in a criminal trial and you're the defendant, you can't be out there intimidating witnesses in the public square.
I mean, that's so that's true. I just don't at this point. All of the posts that I've seen from President Trump, to be President Trump is to say things about people, right? And I don't know that there is a single thing that Donald Trump has posted so far in this case that could reasonably be called witness intimidation.
What about the judge?
I mean,
because
do you think the judge is actually being intimidated by Donald Trump, Bill?
Well, the issue being that he is attacking the credibility and saying that the judge is corrupt and the entire process is corrupt. I can't imagine that in a regular criminal case, that behavior would be allowed.
Right. I mean, so I think that's right. Although defendants are given a ton of leeway, right?
As Trump has been given.
And the thing is, in a typical criminal case, most people don't listen to what the defendant has to say. Let's be honest, by the way, that's just kind of the way our society is, right? Sometimes to our fault, right? We say, oh, well, that guy's on trial, must be a bad guy. That's what a lot of people do. With Trump, it's a little bit different because, you know, it's the spectacle of a former president being tried. And so when he says something, 200 million people are listening to that. Given the necessarily political nature of prosecuting a former president, I got to say, I mean, you're in uncharted territory here,
right?
Sure. You're in totally uncharted territory here. But I think courts trying to muzzle Donald Trump actually do more to harm their own credibility than they would if they just let him talk. I mean, at this point, I think every time a gag order comes out, whether you like Trump or you don't, people say, okay, like, what is this? Who cares? It's just Donald Trump. Of course he's going to say you're corrupt. It's what he does.
Yeah, but I think that it goes a little bit further because you have an entire group of people in this country that believe that Donald Trump is the oracle of truth. and they behave that way. I mean, and I only have to refer back to things like, I don't know, a stolen election. So a lot of people have showed up at an event in the Capitol based on a false narrative. So the idea that what Donald Trump says is the same as what a other criminal defendant says, I don't think sit on the same level. And I can see what you're saying based on the gag order. But again, and the part that I think he's crossing the line is when he starts going after the judge. I can't imagine that is ever allowed in any sort of a criminal procedure that you would allow someone with this kind of a megaphone to impugn the reputation of the judge. And the issue being not just calling the judge and saying this, he's inventing stuff about corruption. So he's making up lies about the judge. And we know that a group of his followers believe anything that comes out of his pie hole is true. That's an issue, isn't it?
Yeah, I mean, I think it's a fair issue, but I mean, you know who is typically subject to speech restrictions in the content, by the way, in the content of any trial.
Yeah.
Right. And anything in the justice system, lawyers.
Yeah,
right?
Of course.
Lawyers, I am one. I know it's hard for your listeners to tell because I'm not hissing right now. But, lawyers, we are subject to...
But you did shed your skin before you got on the air.
I did.
So
I did. I molted before I came in here. Yes. But lawyers are subject to a canon of professional ethics.
Yeah.
And that requires us to show respect to courts. And we're actually very circumscribed in what we can say about courts, both in court and out of court.
Yeah.
Parties are not typically restricted at all in what they can say about the judge. But I'll tell you what most lawyers say to their client, especially if you're on trial, is, hey, it is probably not a great business decision to make this judge angry. Probably a really bad decision to do that because this guy holds your life in his hands or this gal holds your life in your hands, right? Don't make them angry. Don't say stupid things.
Yeah, but then Trump creates that self-fulfilling prophecy, because what he does, just like he's doing now, he wants to get thrown in jail based on violating the gag order, because he knows politically that is a win for him. And so he also knows that by attacking the judge, if the judge does anything to him, it then becomes a self-fulfilling prophecy, because he then goes, look, he's doing exactly what I was accusing him of doing. And so he allows what he claims to be true to then through perception to be true. He's doing this on purpose.
You just nailed it, Bill. And that's why I think every judge who plays along with this, right?
Yeah.
If I were a judge, unless I was genuinely, so I'll say, here's one thing. I don't know Judge Marchand from anybody else. Okay. Yeah. And so I may be wrong about this. I want to be totally clear. I don't know him. I know nothing about him, but I will say, I can't imagine. I'm sure he has had some truly scary men and women in front of him.
Yeah.
Right. Most judges have. They have had some people who you look at and you say, boy, I'm really glad there's a bailiff in here.
Yeah.
Right. I don't think if I were to bet, he's not actually afraid of Donald Trump or Donald Trump's followers.
Oh, well,
right? I detect crocodile tears here. And that's why I would say, don't play along with this.
I would disagree with the followers side. I don't think that he's not afraid of Trump, because followers say a lot of things. And we have a thing right now in the country on both sides of people levying death threats. We just had the Lincoln Day dinner for Jefferson County Republicans canceled because a bunch of loony leftists issued a bunch of death threats. And we have Jenna Griswold getting a bunch of death threats from people on the right that were Trump supporters because she was trying to keep him off the ballot. So she obviously had to be subject to a Second Amendment solution. Those are the threats that are being done. So it's not a direct threat from Trump, but can we maybe, and we've seen individuals that are supporters on both sides drive multiple states with firearms in order to find a solution. It is not out of bounds, based on the megaphone that Donald Trump has, that one or two of those individuals could become convinced and decide, well, I have got to save my man. Yeah. And the only way to do that is with my gun.
I think that, Bill, there's no question that unfortunately, like, one nut job can do a lot of damage, right? But I got to tell you, I tend to think that the odds of a nut job doing something crazy go up if Donald Trump gets thrown in jail for violation of a gag order, right? Yeah, versus if he's allowed to just spew his invective, or occasionally his legitimate points, right? Into space and say, hey, look, and if the judge said, look, this guy's a candidate for president of the United States, I'm a big boy, I'm going to run this trial, he can say whatever he wants about me, go ahead. I actually think there's some people who would have more respect for the judge if he did that.
Possibly. What about the jurors that left because they were already identified and received threats? Because, we have direct causation there. Bill, of that behavior.
Are you trying to tell me you've never tried to get out of jury duty?
No. I got a great one. I know George Brockler. It gets me out of every jury duty I've got ever. That's
he's our BFF. Yeah, I do have a question here, and then I want to get to a break. And if can we stick around and talk about the trial, the classified documents?
Sure,
great. You have a judge who's donated to Biden.
Mm-hmm.
You have prosecutors that have worked in the Biden administration. You have a jury pool that's 87%, likely Democrat. Mm-hmm. At least that's the city that it's come from. Mm-hmm. Do you think Donald Trump's going to get a fair trial here?
I do, in that so far, right? I have not. This is the first case to go to a jury, right? And I'll speak for myself. And, I'm a lawyer. Your listeners will say, okay, well, this guy's a lawyer. Of course he believes in the jury system. I believe in the jury system when it comes to trials. I prefer juries, and nothing against judges, but I prefer juries over judges almost all the time. Why? Because when it comes right down to it, juries typically do a really good job of cutting through to what matters. They're together. They're a human lie detector, right? And they can smell if something actually matters or not. It doesn't mean juries can't get it wrong. And that doesn't mean if I were Donald Trump, I would not be concerned for the exact reasons you say. And if I were his attorneys, I would be concerned for the exact reasons you say. But I will not be surprised at all if a jury comes back with an acquittal in this case.
Talking with Chris Murray, he's a partner with First and 14th Law. He's been on many political campaigns, serving as legal counsel as well as for the state party at one point. We do have a caller in here. Tony, line one. You're on the Jeff and Bill show, News Talk 710 KNUS. Good morning, Tony.
Hey, good morning. Thanks for letting me get in here. The question is for your guest, since he's followed this so closely as an attorney. And yeah. I've been hearing that testimony has been given that around the Access Hollywood tape that got released, it was a super crisis in the Trump team. And so when that happened, Trump, Cohen, Pecker, all of them kind of got together and said, we got to make sure we've buried any of these other stories around these gals. So kind of demonstrating that their efforts were very much around trying to make sure that it did not impact the 2016 election. And then one final comment is when he did win, then I think it was Pecker or maybe Cohen, but one of them in this through testimony had said, oh my God, what have we done? Surprised by the victory and then realizing their efforts may have very well have saved his campaign. Now, that's what I've gleaned from testimony. Is that all wrong, what I picked up?
No, and Tony, thanks for the question. Nice to meet you. So first thing, I think that your first supposition that the Access Hollywood tape, and again, this is the tape where Trump said, talked about grabbing women, by their genitals, that was a super crisis within Trump world. That is absolutely true. There has been testimony that has said that there's been testimony from a couple witnesses that that's what that was. And by the way, that's also just common sense, right? I think that was a super crisis. I think everybody could see that. The second piece on who said the what have we done, that actually was not David Pecker or anybody in Trump world. That was the attorney who represented both McDougal and Daniels in their negotiations for their payments. And I think he texted David Pecker and said, oh my God, what have we done? And so that was his testimony. And I think Pecker verified that he received that text, and that he understood that attorney to be basically saying, oh, geez, what have I done? And I think that attorney also testified to verify that he sent that text. So, and what you've said is everything that you said, basically, other than that, is accurate. And that's the prosecution's theory of the case is exactly that. These payments happened right after Access Hollywood. Obviously, it was to benefit the Trump campaign, even if the Federal Election Commission didn't determine that it was a violation of federal criminal law for those payments to be made.
I want to switch over here because we got limited time to the classified documents case. The Trump campaign just submitted a motion to dismiss based upon selective prosecution. What does that mean?
So selective prosecution, so prosecutors, I think most of your listeners will be familiar. Well, George Brockler used to be in here, right? He was a prosecutor, and he would sometimes talk about prosecutorial discretion. Prosecutors have to they can't charge every crime because there's not enough prosecutors to do it, right? If you charged every crime, especially with all the laws on the books, right? Almost everybody would get charged with something, right? So we all know prosecutors can choose what crimes to prosecute. Selective prosecution means that the prosecutorial policy, right, the way that a prosecutor exercises his discretion, is designed to discriminate, right, and actually has the effect of discriminating against a particular class or a particular sort of person. And so the Trump defense filed a selective prosecution motion to dismiss, saying, hey, look, there's been tons of people who have violated the nation's policies with confidential documents. None of them have been prosecuted in this way. And it appears that Donald Trump is the only one who's been prosecuted this way because he's the chief political rival to the sitting president of the United States. it's actually not a bad argument. I don't think Judge Cannon in Florida is going to touch it with a 10-foot pole, but this is the sort of argument that is being set up for a court of appeals, that under the existing law, and if your listeners want to read the case that is the most recent good case on this, it's United States versus Armstrong, a 1996 U.S. Supreme Court case. And most of selective prosecution dismissals and issues are in the context of racial discrimination, but they can also be based on the exercise of the right to free speech. And that is the basis on which Trump's team is moving to dismiss the classified documents case.
No, the argument that Bill often makes is that this is, I hear these in my dreams, Bill, after I go to bed at night, that, look, yes, Donald Trump took the documents, and yes, Joe Biden took the documents, and yes, Barack Obama took the documents, and yes, Hillary Clinton had an illegal server. But when they were confronted by the archivists, they gave them back. And Trump didn't.
And that's why Trump should be prosecuted as opposed to the others.
Well, that's just what Trump is being prosecuted for. That's what Jack Smith's indictment is. It's the idea that he has not indicted him for having any of the classified documents. He's only indicted him for the ones that were requested back that he then violated when they had the subpoena. And so that's the ones that he's been charged with. So that's the differentiation point in the charges so far.
Right. I mean, so fair enough. I would actually, Bill, I'm going to take you on a trip down memory lane, and if all of your listeners too, because just like with almost anything screwy in our modern politics, right? There's an analog in the Clinton administration, all right?
Sure.
And Bill, do you remember the name Sandy Berger?
Yeah.
All right. So
he put the stuff in his pants in the skiff.
That's right. I mean, and I'll just remind your listeners quickly. Sandy Berger was Bill Clinton's national security advisor.
Absolutely.
Right? After 9/11, the Bush administration requested some help for the 9/11 commission, right, and asked the Clinton administration and actually some representatives from the Reagan and Bush 1 administrations to come in and go through some classified materials and help basically sort them, right, for the 9/11 commission, and basically make sure the 9/11 commission got stuff that at the time when those administrations left office didn't seem important, put it under the nose of the 9/11 commission, because the whole point of the 9/11 commission was, shoot, what did we overlook? How did this happen? Okay, so Sandy Berger was the Clinton administration's designee for this project. He went into the archives 4 times, right? By the 3rd time, the archivists were saying, we think he's shoving stuff in his pants.
Yeah,
right?
They're missing stuff because they have a list of it.
And
it
turned out, by the way, this guy's a lawyer. I mean, he's a barred lawyer in D.C., $1,000 an hour guy. And here's what he did. He was shoving documents down his pants, taking them out of the archives, hiding them under a construction trailer a block down the street, coming back in the dead of night himself, getting them and cutting them into tiny pieces and scattering them in trash cans around the Washington, D.C. To this day, nobody knows exactly what he took. Nobody knows. You want to know why nobody knows? Because he wasn't prosecuted.
Yeah. Yeah, that's okay. We can prosecute him. We should have, but that doesn't. But if we didn't prosecute him, does that mean then that anybody now gets to keep the classified documents? Does that mean it's a get out of jail free card for anybody? So Biden could have the boxes of classified documents from the skiffs loaded up, and he can take them home as treasures afterwards. Is that the operation now?
No. I mean, but I'll just say, right, that the analog that they asked Trump for the documents and he didn't give them back. Which, by the way, it's fair. They absolutely did do that, and that is what Jack Smith is prosecuting him for. And I think it's a smart prosecutorial move to only prosecute on the documents they specifically requested and didn't get.
Yeah,
that is smart, right? But Sandy Berger, they didn't have a chance to ask him for the documents back because he literally went in and stole them and destroyed them. And by the way, I should say, I mean, it's not that he wasn't prosecuted. He was prosecuted. There was a very quiet plea deal. He got probation.
Yeah.
Right.
Which, again, I would assume that in the early stages of this, if Trump would have handed the documents back, there would have been nothing done to this. The only reason he is facing the charges is because he has refused to return the documents. Right. And I understand not prosecuting Sandy Berger, and I understand that, but that also gets into what you see in selective prosecution, because I have yet to find a criminal defendant that doesn't try to enforce selective prosecution. Everybody turns around and goes, you know what? There's a whole bunch of other people doing the same crimes that I am, and you're only prosecuting me, so this is obviously selective prosecution. Every criminal defendant, more or less, makes that argument.
I mean that's. I'll just say that, I think Trump has got a very interesting selective prosecution argument, because
I would agree.
Precisely because he's so unique, right? Precisely because he is the former president. He's a current candidate for president of the United States. We've never seen anything like that before.
Yeah. Is his argument that well, why wouldn't he return him? Is he making the argument that as president of the United States, he has the ability to declassify these documents and he'd like to hold on to them?
Yeah, I mean, he is making that. I mean, we don't know exactly what all of his defense is going to be. He is making that argument. I wouldn't be surprised if he also makes an inadvertence argument, right? Because of how,
but that's going to be a hard one to execute, though. The inadvertence of I didn't know they were around, and the problem is going to be Walt Nada, because he absolutely knows the documents are there, and he goes as far as to move them so that his lawyers cannot find them during a search. So he is well aware of the documents, in fact, has people in the office copying them and downloading them onto thumb drives for electronic classification later. So he's absolutely aware of them. The inadvertence argument of, I didn't know when they were packed and they showed up at Mar-a-Lago, but as soon as he finds them in the box, not bringing them back, the inadvertence argument falls apart. I mean, it just evaporates.
Right. So but my point is that I wouldn't be surprised if his argument goes in a couple stages, basically like a series of unfortunate events.
Yeah.
And then, hey, by the way, why shouldn't I be allowed to have these anyway? Because I declassified them.
Yeah.
Oh, and by the way, nobody takes this seriously because look at all these other people who have done all sorts of crazy things with documents. I mean, I got to give his lawyers credit too. I mean, they reminded me of something that was, before my time, probably before your guys' time too. Another Clinton administration official. Do you guys remember John Deutsch? Right.
Oh, yeah.
Bill Clinton's first CIA director. Right. They mentioned, I mean, this is crazy. I had totally forgotten about it. He had tens of thousands of the most classified documents in the U.S. government sitting on like an old Intel 386 at his house in 1993, like the computer that your mom would have at the kitchen desk, right?
Oh,
he had the CIA's like treasures sitting on that computer with a modem plugged into a landline.
Yeah, that would have been incredibly easy to get into.
Right.
Incredibly easy.
Also not prosecuted.
Chris Murray, partner, First and 14th Law, breaking down the Trump trials. I hope this could be a regular conversation. I think, Fox News has finally gotten the memo that conservatives watching all this want to know the details of what's happening in this case. And for the first 2 weeks of the case, I had to rely on the Washington Post and the New York Times, who had 3 or 4 reporters, to get what was happening. What's the best analysis? This is going to be a totally unique presidential campaign that looks more like court TV than it does what we saw in previous campaigns. So, Chris, thanks so much for being on the Jeff and Bill program.
Hey, my pleasure to be here, guys. Via con Dios.
Jeff and Bill, weekday mornings from 6 to 10 on News Talk 710 KNUS.